Immigration. This is another huge area that's going to only become more so in the next few years. AB 263 basically created a prohibition on, quote, unfair immigration-related practices. Creates a new labor code section, 1019, that prohibits an employer from using immigration law to retaliate against an employee for asserting rights under the labor code. So in other words, if someone complains about something, that their rights are being violated, whether it's a wage and hour complaint or a discrimination complaint or something like that, and the employer uses the immigration laws to retaliate against that person, that's now prohibited and there's serious repercussions to it. An unfair immigration-related practice includes requesting more or different documents than are required under federal law, refusing to honor documents that appear genuine on their face, using E-Verify to check an employee's status at a time or in a manner that's not permitted under federal law. So in other words, E-Verify, you can do it when you have an applicant and you're about to hire them. But if you have an employee who's been there for a couple of years and they file a complaint about wages and you suddenly go and run E-Verify again to figure out if in fact they're illegally in the country, that would violate this statute. And there's a rebuttable presumption that any action taken by the employer that violates any of these unfair immigration-related practices within 90 days after the employee exercised their rights is a violation of the statute, that it's retaliation. So there's a rebuttable presumption. In other words, the burden is now shifted to the employer. If you take an action against that person within 90 days after they file a complaint about some labor-related thing, there's a rebuttable presumption that you have committed retaliation. The statute authorizes a civil action for damages, for equitable relief. It also authorizes suspension of your business license. So it's pretty serious stuff. And that goes hand in hand with SB 666, which is it is now considered under the new labor code section, makes it an adverse employment action to report or threaten to report immigration status because an employee exercises rights in the labor code. Sounds similar, but it also includes threats to report an employee or family members. Family members includes those by blood, adoption, or marriage. And there's no requirement for the employee to exhaust any administrative remedies before they can bring a claim under this. But the real hammer here is under this statute, under 666, that the agency can suspend or revoke your business license. And if a lawyer is involved in it, and the way it would come up for a lawyer would be as if an employee sues and the lawyer is defending the employer, and the employee is either a witness or a party to an action, and the employer reports that person to the immigration services, that lawyer can be disbarred now. So we're talking suspension of business licenses, disbarment of lawyers involved. So in this, immigration is becoming a real serious issue.